Be ready. 5 seconds. Start. This court, in a case, quoted the observations made by the High Court in that case, expressing its views that common man must feel assured to get justice and observed as under stop. Let not the mighty and the rich think that courts are their paradise and in the legal arena they are the dominant players. Stop. These judgments make one thing crystal clear, that criminals do not hesitate approaching courts even by abusing the process of the court and sometimes succeed also. Stop. The instant case belongs to the same category. Stop. Petitioner feels that merely because he is a black marketer and succeeded in exploiting the helplessness of the poor people of the society and is capable of engaging lawyers, he has a right to use, abuse, and misuse the process of the court and can approach any court anytime without any hesitation and without observing any required procedure prescribed by law. Stop. An FIR dated 15 September 1998 was lodged against the petitioner and one other person under Section 7 of Essential Commodities Act 1955 as they were found in possession of 1370 liters of blue kerosene and indulging in unauthorized sale thereof in violation of the provisions of Section 7 of the Act 1955. Stop. After completing investigation, charge sheet was filed and trial commenced. Stop. The trial court, white judgment and order dated 27 October 1999 oblique 2nd November 1999 found them guilty of the said offence and awarded sentence of imprisonment for 1 year along with a fine of rupees 2000 each. Stop. Against the aforesaid order, the appeal of the petitioner stood dismissed by the High Court, white judgment and order dated 30 July 2010. Stop. Petitioner preferred an application dated 25th July 2011 before the High Court for modifying the aforesaid judgment and order dated 30 July 2010, giving him the benefit of the provisions of Section 360 of the Code of Criminal Procedure 1973 and oblique or Section 4 of the Probation of Offenders Act 1958. Stop. The said application was dismissed. Void impugned order dated 19 September 2011. Stop. It may be pertinent to mention that against the judgment and order dated 30 July 2010, the petitioner had filed SLP criminal number 1469 of 2011 on 13 October 2011, which was dismissed by this court wide order dated 27 January 2012. Stop. Subsequent thereto, this special leave petition has been filed on 29 February 2012 challenging the order dated 19 September 2011. Stop. No explanation has been furnished as why the present petition could not be filed during the pendency of the earlier SLP, or both the orders could not be challenged simultaneously as the order impugned herein had been passed much prior to the filing of the first special leave petition on 13 October 2011, and petitioner surrendered to serve out the sentence only on 13 January 2012. Stop. The High Court dealt with various propositions of law while dealing with the averments raised on his behalf, including the application of the provisions of Section 362 Criminal Procedure Code, which puts a complete embargo on the criminal court to reconsider any case after delivery of the judgment as the court becomes functus officio. Stop. This court, in a recent judgment in State of Punjab versus Devinder Pal Singh Bhullar and others, etc., AIR 2012, Supreme Court 364 dealt with the issue considering a very large number of earlier judgments of this court, including Vishnu Agarwal versus State of UP and another, and came to the conclusion stop. Thus, the law on the issue can be summarized to the effect that the criminal justice delivery system does not clothe the court to add or delete any words except to correct the clerical or arithmetical error as specifically been provided under the statute itself. After pronouncement of the judgment, as the judge becomes functus officio stop, any mistake or glaring omission is left to be corrected only by the appropriate forum in accordance with law stop. Learned counsel for the petitioner placed a very heavy reliance on the judgment of this court in Kanta versus State of Kerala and another, wherein this court has held that in case the special petition is dismissed by this court in limine stop.